Welcome, and thank you for joining us today for MAAWG 5, where we connect with experts on core issues and topics in the industry. My name is Amy Cadigan, and I'm the MAAWG Executive Director. Today, I would like to welcome Simon McGarr, MAAWG Senior Advisor.
Thank you very much for having me, Amy. It's a pleasure.
We're happy to have you. Today, we'll explore the intersection of Brexit and Schrems 2. First, Simon, can you tell us a bit about your background and what are the two standout GDPR issues for international companies in 2021?
My background is I'm both a practicing lawyer, I'm a litigation lawyer, and I specialize in data protection work. I've worked for both private clients and NGOs at national and at CGA EU level, that's the EU's top court, on data protection cases. And I think probably the most important things that are going to happen in 2021 in respect of data protection for international audiences are going to be the winding out of the consequences of Brexit, of Britain leaving the EU, and of the effects of the Schrems 2 judgment from last year taken by the Court of Justice in Luxembourg. So those are our two big issues that we're dealing with this year.
Great, thanks. How does Brexit impact the UK's GDPR status? And what is Schrems 2 and why is it crucial to talk about now?
To take them in sequence, I suppose, the first question is, well, how does Brexit affect the GDPR? That's an interesting one because, of course, the UK has been a member of the EU for decades and it implemented the GDPR into its own domestic law as part of its preparations for leaving. So, at one level, one might think that there isn't really much to be changed. However, what has happened is that as they left the EU, the Britain became what is known as a third country, just as the US is or Japan, and therefore Britain has to demonstrate a level of adequacy for the protection of personal data. Now, of course, they start from a good place. They already have the GDPR in their national laws. But what has changed is that as a no longer a member state, what's taken into consideration when considering adequacy of third countries is different to member countries. And the key issue is the access of data by national security and surveillance laws. So the UK is part of the Five Eyes group of countries, and it's going to have to demonstrate that it is adequately protecting data, even though it also has a number of very stringent intelligence and communications interception laws on the books. In respect of the impact of Schrems 2, Schrems 2 is a court case, and as the name would suggest, the second of its kind. Mr. Schrems' first court case both came out of Dublin and were referred to the Court of Justice in Luxembourg. So the court was asked, is it okay in the initial case, is it okay to transfer data on foot of the safe harbor agreement? And the safe harbor agreement was found to be unlawful and was struck down. The EU and the United States then did a second agreement called the Privacy Shield Agreement. And the Schrems 2 decision found that that also was unlawful and it was struck down. However, in addition to the Privacy Shield, they were also bringing into question, was it lawful to transfer data to the United States on standard contract clauses? Now, this was very significant because the standard contract clause transfer method is the primary transfer method of data outside the EU to third countries to protect for data transfers between individual and companies. So, to everyone's relief, the court found that standard contract clauses were inherently permitted, that was allowed. However, it means that the people who are doing the transfers, the data controllers who are transferring to the new country, to the US, are now obliged to perform due diligence on whether or not the terms of that contract are compatible with the laws in the United States or any other third party country that it's being transferred to. And again, this comes down to a clash between competing requirements under the national security and surveillance laws and under the standard contract clauses. So there are some companies who are obliged to transfer data without the knowledge of the individuals into the national security system. And those countries, those companies are having the difficulty of meeting the requirements to show that they have an ability to enforce the standard contract clauses and to ensure that those protections in that contract are valid and adhered to. So, from the point of view of international companies, this is a very big deal, both if you're transferring data out of the EU and also if you're receiving data from the EU and you were used to getting it under either standard contract clauses or under the privacy shield. Both are now additionally complicated. These are the two sort of issues that are unwinding just to make life easier. The European Commission's data protection, beg your pardon, the European Union's data protection group, the European Data Protection Board, issued new draft standard contract clauses in November of last year, which we all now have to absorb, as well as deal with the consequences of the Schrems 2 case. So there's a lot happening this year in international data transfers, and I'll be surprised if we see the full unwinding of those things even by the end of the year. This will probably go into 2022 in order to see the consequences of this finish up.
Great, very valuable information. The Brexit transition period ended at the end of 2020. Are there any consequences for the UK to address after Schrems 2?
So, I mean, as if Brexit wasn't enough, Schrems 2 is an additional complication for the UK as they're moving into their new independent role outside of the EU. So the Brexit trade agreement, which was light but a welcome alternative to no trade agreement with the EU, means that the data flows between the EU and the UK are still being treated at the moment as though they were still in the EU. And that will continue until, on the first instance, the 30th of April 2021, and then finally until the 30th of June 2021. At which point it is hoped that the EU Commission will be in a position to make a finding on Britain's adequacy. And adequacy is an extremely valuable status for a third country. It means that we in the EU will be permitted to treat it as though it were in the EU for the purposes of data transfers. We can consider that country is okay to transfer data to. So, absolutely vital for the British data transfer industry, but also, of course, really vital to everybody inside the international data transfer community who have relied upon Britain's integration in the EU in designing all of their data flows, even in preparing for Brexit. Britain was promising that adequacy was a done deal, a sure thing. After all, hadn't they already complied fully with the GDPR as a member? That's not so clear now, it would have to be said. It looks like there may well be problems about reaching an adequacy, certainly problems for adequacy without any changes to the legislation that's already on the books in the UK. So, if that's the case and there isn't an adequacy decision, that means that the Schrems 2 restrictions on data transfers, which apply to the United States, will just as equally apply to the United Kingdom. So, we're looking at a difficult, bumpy 6 months, or as it is now, 5 months, before we reach the point of finding out whether or not the United Kingdom will remain sort of an integral part of European data flows, or whether it will choose to prioritize national security or the sort of the more financial commercial aspects, which would be more in favor of data integration with the EU. A lot up in the air, very difficult to know which way things are going. And so, for those of us who are not in charge of countries, all we can do is prepare contingency plans for the various different outcomes and ensure that we're ready to implement those contingency plans on the deadlines that we know exist.
Great. Why should folks in the US keep a close eye on changes in the UK? And how will this impact businesses?
I think there's two reasons. One, the UK, as I say, has been integrated very deeply inside the EU's data transfer system. So data flows to the EU frequently ran through London. However, there's also a more sort of, one might say, selfish reason to keep an eye on the UK. Unlike the US is on a time limit for a decision on adequacy. And that means that if we want to find out just how serious the Commission is going to get in implementing the restrictions on Schrems 2, we will find that out first in respect of the treatment of the United Kingdom. If it is the case that the Schrems 2 decision is applied strictly to the United Kingdom, what we're going to meet is a vision of the future in respect of the negotiations between the EU Commission and the United States. Now, things have changed with a change of administration. It's possible that there may be a slight thaw from the very strong positions that were taken between the EU and the United States federal government. However, undoubtedly, the United Kingdom could be seen as the canary in the cage for the seriousness with which the EU Commission is going to take these questions.
Great. Thank you, Simon. We really appreciate your time today and informing our members and our viewers on GDPR and Schrems 2.
It's been a pleasure, and thank you so much for paying attention to what can be something of a niche topic, but I think actually is going to be very live this year.
Great. Thank you. And for those of you watching, if you have any suggested topics or would like to participate in MAAWG 5, please reach out to us via the contact form on the MAAWG website. Stay tuned for our next edition of MAAWG 5.